FEMA. Friends, as you are aware that our webinar series began in 2020 when COVID impact has started, and driven by the enthusiastic response from our participant and the expert, those who were ready to share the knowledge, we have reached to this milestone on 198. And because of the support and eagerness to learn have motivated us, so we are continuously holding our webinar on every Friday 4 to 6 without any interruption. Till date, 1,35,000 people have registered in our webinars. Thank you for joining us today, and we look forward to an engaging and insightful discussion and session today. Friends, I just want to inform all of you, this is our 198th webinar. On 20th December, we will have our 200th webinar. The most prominent speaker will be there to speak on catalyst for corporate growth, unveiling the next wave of regulatory reforms. This topic we have selected on the basis of that what is future lies and what is the expectation of regulator and the industry. We will discuss this issue. Coming to today's topic, as part of the government's commitment to promoting ease of doing business or ease of investment for investor, in line of the budget 2024-25, where Finance Minister Nirmala Sitaram presented budget in the Parliament and mentioned that they will simplify rules and regulation for foreign investment. When we talk about the investment, so you can understand that there is a bound to be mistake also. So investment is there, but if there is a stigma, you can't do others. So that's why they came out the new compounding rules. So the Department of Economic Affairs and Ministry of Finance notified Foreign Exchange Rule 2024 on 12 September 2024 under Section 15 on FEMA Act 1999. Friends, Section 15 of FEMA 99 grants the power of compounding contravention and permit compounding of contravention upon an application by the person committing such contravention within 180 days of receipt of application. These new rules have superseded the erstwhile rule laid down in year 2000. The primary aim of these rules is to streamline the compounding process by clearly defining the offense eligible for compounding and specifying the offense authorized to handle such contravention. Who is the officer who can handle this? Key changes including more efficient processing of compounding application. The introduction of digital payment option is also introduced of the fee and penalties, and simplified provision removing any ambiguity. The key discussion point in the webinar will be compounding under FEMA and importance, overview of the new rules and key changes, the compounding process step by step, and practical implication for business. As you are aware that there is a new set of ideas coming in the regulatory bodies also, like SEBI, MCA. They are aware, and the government also, that they are decriminalizing the various section. When the decriminalization is removed, then it means that next base is compounding or consent. SEBI called consent, and the company law and RBI is called compounding. So when the compounding and consent process, they want to start because now they want to decriminalize. And simultaneously, when you are doing compounding, so there are two types of compounding. One is you have violated some technical process, like you have filed late application, you filed something delayed by 2 days, 5 days, or some mistake you have done unintentional. But every law is talking about the fraud and other thing they are not doing. and the habitual person who is doing mistakes, they are not doing compounding. But for remaining, this was the ease of doing business, that they want to do something where the compounding process should be very simplified. Compounding process should be more easy. Technology used should be there, and the payment process should also be simplified, like online payment. Earlier, you have to go and deposit cash, then you have to deposit DD, deposit this. All these things were there. So now, all things are they are coming out what is needed today. So today we will discuss all these points, and I want to extend a very hearty welcome to our learned speaker, Mr. Ankit Singhi, who is Head Corporate Affairs and Compliances, Corporate Profession, and Ms. Shweta Agrawal, Senior Associate Corporate Professional. Ankit and Shweta both are doing the FEMA work, and they interact with the companies. They do for compounding. They suggest various strategy to the client and working out. The program structure will be that Ankit will tell us today what is law, what mistakes company normally do, which is a violation, and what is the penalty which can be compounded and which cannot be compounded. Because what types of penalties are there which can be compoundable. Now, in the same process, today in the program, Shweta and Ankit both will discuss the first definition of compounding. What is compounding? Who is the authority? Because in the FEMA, RBI and ED, the both are the authority. And if there is a scheduled offense part of the PMLA, then ED do compounding. Which office can do, because they have given power to the regional office and the head office. Who can file, who has a locus standi to file, when he can file, when he cannot file, what is the process of compounding, and point of consideration that they will discuss. On which case compounding is not possible, what are the considerable consideration when compounding is not possible. Uh, then personal hearing or is a direct process, that is also we'll discuss. Compounding policy, that is a very interesting point which we'll discuss today. Now RBI also has, like SEBI has done, the chart process, that, like for example, the RBI is prescribing that if less than 10 lakh 1000 rupees per year, less than more than 10 lakh but less than 40 lakh 2500 rupees per year, like this they have given the all calculation also. So the discretion or officer is removed. You violated, calculate yourself and deposit. So that is one part. uh, then there are so many other factors which are determining the compounding, because sometimes what is happening, they have both the power, remove, reject it, or determining that you have done a mistake, it's a bona fide mistake. How to do payment, role of AD bank, and then we'll do question answer. Friends, no doubt the law is changing, but certain processes also still require more modification, and that day is not far when we will realize to see that you have done violation, you got a notification, and then you are depositing the money, and the violation is good now. So that way, this is the primary thinking of the government, and they want to do it. So let's start with this. That what is RBI is prescribing, and friends, if you have any questions, please write to us immediately. Our panelists will give answer to this. Now I will request Ankit to give overview on the subject. Then Shweta will give a detailed presentation and on compounding. And this presentation we'll share it with the our participant. And simultaneously, I want to inform that our next webinar of 199, 1 less to 200, it is on 13th December. That is maternity code for ESG analysis that we will do, because ESG is a word now. And now I request Sweta, first Ankit, please tell us or give the overview on the this FEMA new compounding regime.
Hi, sir. Very good evening. Good evening to all the
Ankit,
participants.
your voice is low.
Hello, am I audible now?
Little bit more.
Little bit more. Always challenge. Hope I am audible now.
Yeah, speak louder.
Yeah. So very good evening to all of you. So today we are here to discuss the new compounding regime under FEMA. So FEMA is always a very complex and dynamic law. First of all, because of the structure in
Ankit, you
which.
have to speak louder. Speak the voice is very low because this is a very technical subject. One should
Hello,
understand.
Shweta. I'll let you know when you need to change this. Right, I am fine now.
Better, but not good.
I have to work along with this as of now. So I was on the FAME Act itself. So it's FAME Act itself is a very complex and dynamic act because of the fact that if you see the act itself is very brief, and the substantial portion of the act is in terms of either regulations, rules, and master directions in many cases. So for any person who wants to do or understand FEMA or undertake any compliance, he need to be aware of the FEMA Act, consent rules and regulations, and then the master directions on the top of it that the RBI issues from time to time. So therefore, it becomes much important and also difficult at times to ensure compliance of various provisions concerning FEMA. When we are talking about compounding, I think the main reason why compounding is such an important topic under FEMA is because of the complex nature of the law, and there are a lot of procedural aspects. Sir, you are on mute.
You have to do something with your voice. It's not coming properly.
Hello, is it
Yeah,
fine now?
and you can speak louder. One is
Okay,
that, and second is louder.
okay. So, okay, I was on to the compounding. So the reason why. Uh, hello, is this fine? Hello.
Shweta, are you also
Sir, from in my system, sir's voice is fine.
Okay, so let me move ahead with this. So I was talking about the compounding regime. So why we are talking about the compounding regime? Even RBI also have issued a new rules for proceeding the existing compounding rules is because of the fact that the law itself is very dynamic, and there are a lot of procedural aspects that are there, and a lot of things there is requirement of seeking any approval, doing or reporting to RBI. So as a result, at times even small violations like delayed reporting of FCGPR, delayed reporting of even allotment of ESOPs. At times, we found that many individuals who go abroad set up a company, which was because setting up a company abroad is easy. They do go and set up a company, and then when they come back and they have to send certain funds to the company, they find it that they have not done any reporting when they form the company. So there is a default. So there are a lot of cases under FEMA where very routine nature of non-compliances are there, and then there are substantial non-compliances. Like for example, you have written off any loan, any investment beyond certain amount for which your approval is required, or you did some investment through some routes where which was not allowed. Even under LRS, you spent some money for certain purposes which was not allowed under LRS. So there are a lot of cases under the FEMA, including the rules regulations, where a lot of procedural compliances and substantial compliances are there, and at times due to a lot of things being there, we forget to tend to attend to the compliance. And in most of the reasons where individuals are involved, I've seen that it's only because of the lack of awareness that there is something where there is certain law that's need to be complied in terms of when you do a remittance or when you do a set up a company or you do any kind of a commercial transaction with any foreign counterpart. Even in case of import and export, we see a lot of proprietorship firms and a lot of Indian businesses that enter into import and export transactions. At times, write off their import bill or export write off their receivables from exporters. When they do export, they write off the receivables, which is in many cases requires approval of the AD bank and in RBI also. So there is a lot of lack of awareness also because of the complex nature of the law itself, which leads to a lot of violations of the provisions of the act, rules or regulations or master directions in many cases. So therefore, in those cases, it becomes important for us to understand the compounding regime, because as opposed to FERA, where many contraventions under the Act were subject to imprisonment. What is good under the FEMA, that there is no imprisonment for any non-compliance. All non-compliances are subject to monetary penalties, and therefore, as a result, because these are subject to monetary penalties, most of them, except to the extent there is a prohibition, most of them can be compounded under the compounding rules as issued by the RBI under the FEMA Act. So to begin with, let's first understand actually what is a compounding. Why we have heard under compounding under various laws. Shweta, if you can move. So compounding, the RBI FAQs itself highlights what is the compounding. It's a process which is voluntary admitting the contravention, pleading guilty and seeking redressal. So what is important in this case of compounding is that you have to admit the contravention. Without admitting the contravention, you cannot go for a compounding. So first and foremost, compounding is requiring that you admit a contravention, admit that something wrong has been done, either inherently or for any other reason. And then you are going to seek a redressal, that I have come with you with open hands. I admit that there is a default that has taken place, and I am here to compound it. So you can go and get it compounded, where RBI levies certain fees instead of the exact penal amount, that is, which can be levied up to 3 times of the amount involved under the provisions of the FEMA Act. You can pay a certain amount which is much lesser than the final principal monetary penalty that can be levied upon you. Next. Shweta, next. So penalties, as I mentioned, under the penalties, there is no imprisonment. Either both are quantifiable penalties, monetary penalties. In case of breach of FEMA Act rules and regulations, 3 times of the sum involved, where it is quantifiable, and up to 2 lakh rupees. Then there is also a penalty for continuing offense. For example, there is a delay or certain thing which is of continuing nature. Then you can said to be in default, which is of a continuing offense. Then there is a specific separate penal provisions for acquisition of foreign exchange security abroad in non-compliance of the FEMA provisions. Then there is also up to 3 times of the amount involved, but it also talks about confiscation and in certain cases imprisonment. Power to compound. Next. Section 15 gives the right to the RBI and Enforcement Direct to compound the contraventions committed by a person under FEMA. And in lieu of that, foreign exchange compounding proceeding rules were issued recently, which superseded the foreign exchange compounding proceeding rules 2000. If you see in most of the cases, RBI in last many years, if trying to come with new rules and regulations superseding the old rules and regulations, and all the new regulations tend to be more user friendly, brings ease of business, and tries to bring a lot of clarity in terms of which were not there in the erstwhile regulations or rules. So therefore, the new rules also try to bring a lot of clarity, a lot of ease of doing business by including certain business related measures. Next. So when we talk about compounding, as I mentioned, there is a reference under other law. Even Companies Act talks about compounding. In SEBI, there is also a settlement mechanism which is called consent. But under SEBI, you can go for a consent without admitting the guilt. It is not necessary to admit the guilt in all the cases. While we discussed in FEMA, in all the cases, it is necessary for you to admit the contravention and plead guilty, and then only RBI will consider your case for compounding. Similarly, under Companies Act, you go and accept the default, which are punishable with fine or punishable with imprisonment, fine, or so in those cases, the offences are compoundable by under the Companies Act also. Under FEMA, as I mentioned, monetary penalty wale compliances are compoundable. Next. Now, compounding authorities, I think Shweta will take from here, and she'll run you through to the entire process as to how the compoundings are done, what are the nitty-gritties involved, what things you need to check in terms of while preparing for the compounding application, and various other associated aspects. To you, Shweta.
Thank you, sir. Good afternoon, everyone. So as I have told about the basic concept about the compounding and introduction with respect to the compounding, now we'll understand about the compounding authority, that who is empowered to compound the contravention. So FEMA Act gives the empowerment to the Reserve Bank of India and to the ED Directorate of Enforcement to empower the contraventions undertaken by a person under FEMA Act. So RBI is empowered to compound all the contraventions under FEMA Act except the contravention which is compoundable by ED, that is contravention under Section 3A of the FEMA Act. So what is Section 3A? Section 3A basically prohibits a person to deal in or to transfer any foreign exchange, foreign security to anyone who is not an authorized person. So with respect to Section 3A, all the contraventions are required to be compounded only by the ED. All other contraventions will be compounded by RBI. Even RBI has designated the officer along with the office, that is the regional office or the central office, to compound the particular offense. So thereby an applicant who has accepted or admitted a contravention, they need to ensure that while submitting an application, they submit the application with the correct officer and the designated office under FEMA Act. So under RBI, authority to officers are given with respect to their ranks, and authority to their office, that is the regional office or central office, is given. With respect to the ED, for the ED, authorities to the officer in consonance with the amount of contravention involved has been designated. Now, first speaking about RBI officer who is designated to compound the application in respect of their rank are like, for the contravention amount involved not exceeding 60 lakh, an officer not below the rank of assistant general manager is designated to scrutinize the application and to compound the contravention therein. For the amount not exceeding 2.5 crore, an officer not below the rank of deputy general manager. For the offenses covering within 5 crore rupees, the rank of general manager is designated to compound the contravention. In case the amount of offense involved in the application is exceeding 5 crore rupees, so any officer in RBI not below the rank of chief general manager is designated to compound the contravention. This was with respect to the compounding office, the officers under RBI. Now coming to the regional office or the central office who is designated to compound any contravention. So with respect to the regional office, contravention with respect to foreign direct investment regulatory framework, and any Indian entity who has committed any contraventions which are specified therein, which we will discuss, if they have committed any such contravention, then they are supposed to file the application with the RBI regional office. And how they are going to identify the regional office, that is with respect to their registered office. So in whichever state their registered office is, they have to go ahead with the regional office of RBI, which is designated for that particular state. So with respect to FDI Regulation 2000, Para 9(1)A of Schedule 1, which talks about allotment of shares or convertible debentures post 30 days from the date of receipt of amount of consideration. So the provisions lay down that an Indian entity is required to allot instruments to the person resident outside India within 30 days from the date of receipt of the consideration amount from them. So if an entity which has allotted equity instrument post 30 days, they have contravened the respective provision, and now they have to go ahead with the compounding of the same, and to regularize the same, they have to submit an application with respect to this provision to the regional office. The other contravention is with respect to delay in reporting of Form FCGPR. In case there is any delay in reporting of Form FCGPR, delay in reporting of Form FLA return, then the company is required to submit the application with the regional office. Para 8A of Schedule 1, which talks about the mode of payment of issuance. So under FEMA Act, and they are read with the non-debt instrument rules and regulation, mode of payment for the foreign investor is specified by RBI. And at the time of making the payment with respect to the consideration of share instruments, the foreign investor is supposed to comply with that mode of payment. In case the contravention has been made with respect to the mode of payment, then the company has to submit an application to the RBI regional office. The next contravention is Para 5 of Schedule A, which talks about the pricing guidelines. So whenever an Indian entity is allotting any equity instrument, they shall ensure that they have undertaken the proper pricing, they have complied with the pricing guidelines, undertaken the proper valuation report therein, and if there is any contravention with respect to the said provision, then they have to go ahead with the regularization of same by submitting a compounding application. The next provision talks about acquisition of immovable property. In case there is a contravention to the same, then you have to submit the application. The next talks about issue of shares without approval of RBI or government wherever it is required. So in case the provision says that an Indian entity cannot allot equity instruments to a foreign investor who is associated with the land sharing border, who is the citizen or who is incorporated into the land sharing border of India, then before making the allotment, the Indian entity is required to get the approval from the RBI. So in case the said approval has not been obtained, then the Indian entity has not complied with the said provision, and they have to go ahead with the post facto approval, and then post obtaining the post facto approval, they have to submit an application with the Reserve Bank of India regional office. Continuing with the other provision under the said regulation, it talks about the pricing guidelines for convertible instrument. The other one is talking about the transfer of equity shares or convertible instruments. So if the transfer of equity instruments has been taken place from one investor to the another investor, it is to be ensure that the transfer guidelines has been complied with. In case receiving investment in India from a non-resident or taking on record transfer of shares by investee company, if the Indian entity has not complied with regulation 4, even then they are supposed to submit the application of compounding with the regional office. So this regulation 4 is quite technical. It says that Indian entities are required to ensure submission of form FCTRS approval from the transferor or the transferee, whosoever is resident, before taking note of the share transfer in their books. So Indian entities are liable to ensure that the proper reporting requirements has been complied with by the resident transferor or the resident transferee or any person who is liable to submit form FCTRS. In case that submission has not been made, or the submission has been made, however, the RBI has not given approval to the form FCTRS, then Indian entity is not eligible or is not permitted to take on record that particular transfer. So before taking that, Indian entity shall ensure that approval to form FCTRS has been done. Now, the other regulation 14 talks about reporting of this downstream investment to the DIPP. So the Indian entities who have made downstream investment into any other Indian entity is required to comply with the 2 layers of reporting. One is with the DIPP and on the firm's portal. So if a non-compliance has been made with the downstream investment reporting requirements, then the Indian entity shall submit an application to the RBI regional office to compound their default. The other regulation of FDI, regulations 2000, talks about FDI in LLP. So as similar to the company, even the LLP who has received FDI is supposed to comply with the provision of mode of payment and reporting compliances. And the last regulation talks about transfer of equity instruments as a gift. So whenever a transfer of equity instrument as a gift has been taken place, the transferor and the transferee shall ensure that they have complied with the provisions with respect to gift. And if they have not complied with the same, then they are supposed to submit an application with the RBI regional office to compound their default. Now coming to FDI regulation 2017. So as similar to 2000 regulation, 2017 regulation, certain provision, if any non-compliance has been taken place, then the application is required to be submitted to regional office. And the non-compliances can be with respect to submission of ARF on delay basis or non-submission of the same, delay in reporting of form FCGPR, delay in reporting of form FLA. If you have not reported the forms within the specified time period, then you are supposed to get them regularized. The next provision, para 2 of schedule 1, talks about the mode of payment, as stated that the rules and regulations lays down the provision with respect to permitted mode of payment for the foreign investor. Indian companies shall ensure that that provision has been complied with, and if not, then they have to get the same regularized. Regulation 11 talks about pricing guidelines at the time of making allotment of equity instruments to the person resident outside India. But then then the next provision talks about permission to a person resident outside India to make investment in an Indian entity. So if any person has not complied with the regulation 2 clause 5, read with regulation 5, then they are supposed to submit an application to the regional office. Regulation 16B talks about issue of shares without approval of RBI and government wherever required. So if the allotment of equity instruments has been made without obtaining the approval of RBI or Central Government of India, then you have to obtain the post facto approval, and post receipt of the post facto approval, you have to get your non-compliances regularized through the compounding as per the conditions specified in the approval given by the RBI. Regulation 13(1), subpara 4 talks about delay in submission of form FCTRS. If you have not submitted form FCTRS within the specified time period of 60 days from the date of transfer or receipt of consideration amount, whichever is earlier, then you have not complied with the provision and you have to submit an application with the regional office of RBI. The next provision, regulation 4, talks about receiving investment in India from a non-resident or taking on record transfer of shares by the investee company. So this is as similar to the regulation which I have talked about under regulation 2000, that the Indian entity shall ensure that they have taken record of the transfer of equity share from one investor to the another investor post receipt of approval of FCTRS from the RBI. So they have to ensure that reporting of FCTRS has been complied with. The next provisions talks about delay in submission of downstream investment or delay in reporting of FDI in a limited liability partnership form. Then you have to again go to the RBI to get the same compounded through their regional office. And regulation 10(5) talks about transfer by way of gift through one investor to the another investor. So you are supposed to comply with the provisions stated therein with respect to the gift. Now coming to the NDI rules 2019, which are the current regulations with respect to FDI. So NDI talks about non-debt instrument rules, and these are the latest and the current regulations for the foreign direct investment. So this rule, if any person has not complied with the provision of this rule, that is rule 2K read with rule 5, that a person resident outside India who is permitted to invest in Indian entities. So if you are not complied with the provision stated therein, then you are supposed to go to the RBI regional office to get the same compounded. Rule 21 talks about the pricing guidelines. As stated before, Indian entity who is issuing any equity instrument to any person resident outside India, they are supposed to comply with the pricing guideline. They shall submit the respective valuation report at the time of reporting with the RBI. The next provision talks about issue of shares without approval of RBI or government. So if you have allotted equity shares without obtaining RBI approval, then you have to go and get the same regularized. Receiving investment in India from non-resident or taking on record transfer of shares by investee company. The other provision talks about transfer of equity instruments by way of gift. So if you have not complied with any of these provisions, then you have to submit an application. NDI regulation 2019 talks about the mode of payment and reporting requirements. So if any person has not complied with the mode of payment provisions or the submission of form FCGPR, FLA, FCTRS, LLP1, LLP2, which are the specific form for reporting of FDI in LLP, or if there is any delay in reporting of downstream investment, then the person who is required to or who is liable to submit the respective form shall submit an application with the regional office to get their contravention compounded, and accordingly they have to proceed with the provisions. Now, as RBI has stated, the contraventions which can be regularized and compounded by the respective regional offices only. Certain contraventions under FDI regulation can be compounded by the central office. That can be the central office New Delhi and the central office Mumbai. So this is not only for the FDI, so entire rules and regulation under FEMA Act are divided into the offices under RBI. So if the contravention is with respect to establishment of license office, branch office, or project office, then the application is not required to be submitted to the regional office. The companies are required to submit the application to the central office, which is situated in New Delhi. Similarly, if there is a non-compliance with the deposit regulatory framework, or if the non-compliance pertains to acquisition of immovable property in India or outside India. So for these particular 3 regulations, Central Office New Delhi is designated to compound the contraventions undertaken by any person. Now coming to the contraventions which can be compounded only by Central Office Mumbai. So the contraventions under the regulatory framework of overseas direct investment, external commercial borrowings, liberalized remittance scheme, import or export of goods and services. So if any person has committed any default under these provisions, then they are supposed to submit the application to the Central Office Mumbai. With respect to the FDI provisions, we have talked about the contraventions which can be regularized by this RBI regional offices. However, there are certain contraventions which can be compounded only by the central office, which is situated in Mumbai. So the very first is with respect to delay in reporting of form ESOP, DRR, INVI, form convertible notes. So if any person has not complied with the provisions with respect to these forms, then the company or the person who is required to submit these forms shall submit an application to the Central Office Mumbai to get their contravention compounded. In case with any non-compliance with the provision which are not specifically stated for the regional office, all those contraventions under foreign direct investment regulatory framework can be compounded by the regional office Mumbai only. Further, any contravention under the FEMA Act, which has not been stated for the Central Office New Delhi or RBI Regional Office, all those contraventions can be compounded only by the Central Office Mumbai. So the contravenor is required to prepare the application and submit the same with the Central Office Mumbai in order to get the same regularized and compounded. Now coming to the contraventions which can be compounded by the ED only. So any contravention which is of a serious nature, vis-a-vis like transactions suspected for the money laundering, transactions with respect to the terror funding, which are affecting sovereignty or integrity of the nation. So any such contravention can be compounded by the ED only. Further, transaction attracting provision of section 37A of FEMA Act, that can be compounded by Directorate of Enforcement only. But the section 37A deals about, it talks about the assets held outside India in contravention with the FEMA Act. So any person who is resident in India holding any asset outside India and that holding of asset is not in compliance with the provisions of the FEMA Act, then section 37A triggers and ED is only authorized to compound the said provision, the said contravention. Further, if the contravenor fails to pay the sum for which contravention was compounded by the RBI within the specified period stated in the compounding order, then even the RBI forwards the application to the ED to look into the matter and restart the whole investigation and scrutinize the application and get the same compounded by the ED. So if your contravention has been compounded by RBI and under the compounding order, RBI has given a particular amount which is supposed to be paid as the compounding penalty within a specified time period, which in general is 15 days from the date of the order. If the person or if the applicant is not paying that particular penalty amount, then your application can be treated as an application which was never received by RBI or never taken into note by RBI, and then the said contravention will be taken note by the ED, and then investigation or the scrutiny of the application can be started by the ED. So it is very important that the applicant or the contravenor pays the amount of penalty imposed by RBI. Further, transaction involving contravention under Section 3 of the FEMA Act, which we even talked about, that this particular section deals with the transfer of any foreign exchange or security to any person which is not authorized to deal in with or to transfer the same. If there is any contravention with respect to the said provision, then only ED is permitted or ED is designated to compound the said contravention. So now coming to that, when you are applying to an application with an ED, so who is the designated ED officer in consonance with the amount of offense involved into the application? So if the amount of contravention is not exceeding INR 5 lakh, then any officer of ED not below the rank of deputy director is designated to scrutinize the application and issue the compounding order. If the contravention is more than of 5 lakh rupee, but within the limit of 10 lakh, then the application will be scrutinized by the officer not below the rank of additional director. If the amount of contravention is less than 50 lakh, then the rank of director, rank of officer would be the special director. If the amount of contravention involved therein is less than 1 CR, then the officer not below the rank of special director along with the deputy legal advisor is designated to look into the application and scrutinize the same. And if the amount of contravention is more than 1 CR, then any officer which is not below the rank of director of enforcement along with the special director is designated to scrutinize the application and issue the compounding order. So now coming to that, who can file the compounding application? So FAQs on compounding of contravention under FEMA 919999 talks about that any person who contravenes any provision of FEMA Act read with any rule, regulation or notification or direction or order issued therein, if there is any contravention by any person, then that particular person is supposed to file the application with the respective authority and to the respective office. Now, the very important question comes into the mind that if any Indian entity has contravened any provision under FEMA Act, whether the director is also required to file an application. So section 42 of the Act therein comes into the picture that states that every person who was in charge to conduct of the companies at the time of the contravention, all those directors, all the management people, every person is liable to guilty, like they will be treated as guilty and they are liable to be proceeded against and punished accordingly. So any director who was there in charge of the conduct of the company at the time of the contravention, then they are also there into the picture and the proceeding can be taken on them as well. So when to file an application? So if you know that there is a contravention, then it's important to know that when you can file an application. So there are 3 ways: suo moto, you have received any RBI instruction, or upon receipt of MOC. MOC is Memorandum of Contravention. So suo moto means that you yourself goes to RBI, let them know the contravention undertaken by you, and then you ask them to compound the same. So whenever any person who identifies the contravention which has been taken place by them, and that identification can be done during the internal due diligence or the statutory auditor. So whenever you get to know through these modes and you know that a contravention has been taken place, then you yourself can prepare the application and go to RBI to get the same compounded, or to the ED, whosoever is the respective authority. Then upon receipt of RBI instruction, so this is the second way, and in general, direct RBI instructions or the AD bank instructions are issued in general in the cases of delay in the reporting requirements. So whenever any person who is liable to report any kind of a transaction undertaken under FEMA Act, they shall, when they submit the form and the form gets approved, the form approval comes with a conditional acknowledgement or the conditional approval having a statement that this approval is subject to submission of compounding and following of the instruction of compounding. So RBI has given you an instruction, or the AD bank has given you an instruction to submit a compounding application to the RBI and get your contravention compounded. The last way is the MOC, Memorandum of Contravention, issued by RBI. So whenever any person who was supposed to submit to take any approval from the RBI before undertaking any transaction, so they have executed the transaction, however the approval has not been obtained, so there is a contravention now, and now you have to go to the RBI to obtain a post facto approval, in which you state to the RBI that this is the transaction I have undertaken. However, as per the Act and the respective rules and regulation, I was not supposed to undertake that transaction before getting approval from your good office. However, I have undertaken the said transaction. So now kindly issue a post facto approval to me and allow me to regularize the contravention undertaken by me. So RBI office undertakes the scrutiny over the overall facts of the execution of the transaction, and at the time of approval of that already executed transaction, they issue a list of contraventions undertaken by the company and give a post facto approval to the Indian company or the person who have undertaken the transaction, and that list of contravention is known as the Memorandum of Contravention. So in case you receive an MOC from RBI, then following the instructions of the MOC, you are supposed to submit an application to regularize the non-compliances undertaken by you. So now you know that who can file the application, when to file the compounding application, to whom to file the compounding application, that either you have to file the application to the RBI, if RBI, then to which office, regional office or the central office or the ED. We have talked about all these concepts. Now let's go ahead with the process of compounding. That now I know that these are the contraventions undertaken by me and I'm supposed to submit an application of compounding. Then what is the process for the same? So the very first action is submission of compounding application by the applicant physically or through Prava portal, along with the payment of compounding fees. So currently when you prepare the whole application following the format given by the RBI, you submit the same either physically or through the Prava portal. When you submit the same, then RBI takes on the scrutiny over the facts and the information submitted by you. Post analysis of the same, the officer can seek certain information or the additional information or documents from the contravenor, and the same is required to be submitted. That is what the second step talks about, submission of additional documents or reply to the queries if sought by RBI. So if the RBI officer comes up with any additional requirement, then the contravenor shall submit the said required documents, or they have to reply to the queries raised within the specified time period. So whenever RBI raises any kind of such requirements, they give you a specified time period within which you are supposed to reply. So it is very important to comply with that specified time frame and submit the reply to the RBI. Now, upon scrutiny of the complete application, along with the additional documents or the queries raised by the RBI officer issues a letter in which they ask the contravenor to confirm the contraventions undertaken by them. And along with that letter, they gives an opportunity of personal hearing. So here, once the RBI completes the scrutiny or analysis of the application, they issue a fact statement to you in which they underlines all the contraventions undertaken by the company or the person, and then along with that they gives an opportunity of personal hearing therein. Now the next is, once you give the confirmation with respect to the facts and you get a reply to the opportunity of personal hearing stating that whether you are opting it out or not, then RBI issues a compounding order. So if you opt out for the personal hearing, then RBI directly issues the compounding order. However, if the contravenor or the applicant has opted for the personal hearing, then they get a particular date and time from RBI. They go ahead with the personal hearing, they submit the facts therein in front of the officer, and post analysis of the submission given in the personal hearing along with the application, RBI issues the compounding order. So overall, this procedure takes 180 days from the date of submission of the application. That is, and here the application means an application with the complete facts and documents. So that from that particular submission date to the date of order, the whole process takes maximum 180 days. And once the order comes out to you and RBI demands a particular compounding penalty, along with they give you a specified time period. In general, it comes with 15 days that the contravenor is required to submit that compounding penalty. So this is the overall process, that you draft the application, you submit the same with the respective RBI office. Then post scrutiny of the application, RBI can come up with additional requirements, which can be the document, or they can ask you certain questions. Once you reply to the same, RBI analyze the overall application along with the additional things, and they draft a letter, a fact sheet, in which they ask you to confirm all the facts and gives you an opportunity of personal hearing. So here for the personal hearing, the contravenor has an option to opt it or to opt out. And once the personal hearing is done, if they have opted for it, RBI issues the compounding order, and then you have to pay the compounding penalty. So the overall time period comes up with 180 days till the time of compounding order. So while you are coming to RBI in order to submit, in order to get your non-compliances regularized, there are certain points which are very important to take note. So the very first point is implementing the corrective measures to rectify the default in compliance with the legal provision and obtain necessary approval. So whenever you are drafting an application with respect to, for example, FDI regulatory framework, so you have done any non-compliance under the FDI regulatory framework, so you have to submit all the information with respect to transaction undertaken by the company since the date of incorporation. So you have to identify all the non-compliances undertaken by the company from the date of their incorporation till the time when they are submitting the compounding application. So taking an example for the ease, that a company got incorporated in 2010, they received the very first FDI in 2015, and in 2024, they received an instruction from RBI or through the internal due diligence or at the time of statutory auditor, they underlined certain non-compliances undertaken by the company during that whole tenure. So when you are now drafting the application, you have to submit all the facts with respect to foreign direct investment, all the transaction undertaken by the company since the time of 2015. It's not that you are just submitting the details of the transactions in which you have committed any contravention. You have to submit the details with respect to FDI since the time company received the very first FDI or its date of incorporation. So you have to identify all the contraventions undertaken. Then you have to make sure that all those contraventions has been rectified. So whatever legal requirement was there to comply with that particular transaction, the Indian company or the person or the applicant is required to first rectify that contravention. So if you have not rectified the contravention, you are not eligible to go ahead with the compounding. So this is a very base requirement of compounding. So rectify your contravention, take the corrective measures as per the legal provision, or if that legal provision require obtainment of any approval from the RBI or central government, then you have to even take that. So once you do the rectification, then you go ahead with the compounding, submission of compounding application and all other things. The second point which is required to be kept in mind, that is preparing and submitting the application to the appropriate RBI office. So if your application was supposed to be submitted to the central office Mumbai, and you have submitted the application to the regional office, which can be the Karnataka RBI office. Okay, so now you have submitted the application to the wrong RBI office. So your entire application can come back to you. So they'll completely return the application to you, and then you have to forward that application to the correct RBI office. So it is very important to identify that which RBI office is designated to compound that particular offense. So the other point is drafting the application in the prescribed format as per RBI guideline. So when you are drafting the application under the compounding rules, RBI has given a format of application along with the annexures, list of annexures required to be submitted. So it's very important to follow that format, and that format is requires certain information specifically in certain things which you get through the experience. So you have to submit all those details, all those sorted documents with RBI. In case you have made any mistake at the time of drafting of application, or you have not followed the format given by RBI, your whole set can come back to you, giving you a return letters with a statement that kindly submit all these documents or kindly provide all these information as per the prescribed format under the RBI guidelines. So it is very important to follow the format, and you cannot play with the format given by RBI. The next part is, it is very important to include the details of authorized officer for the correspondence. So whenever RBI have any further query, or they are hoping for a certain document, they have to come back to you, they have to communicate with you. So it is very important that you mention the contact details, that is the email ID, the contact number of the authorized person in the application, so that RBI contacts the correct person. And here the authorized official, it is very important that the person knows in and out about the contravention. They know that what has been stated into the compounding application. They know the fact of the case, the reason of contravention, your pleadings stated into the application. So this authorized person shall be aware about all the things, the provision of FEMA Act, so that whenever they get any call or email from RBI, they are able to understand that what RBI officer is asking for, and they can accordingly communicate or provide the respective information or documents to the RBI officer. The other part is conducting a thorough due diligence of past transaction to identify the defaults in seeking regularization of same. So as I talked about while taking the rectification of the contravention, so you have to take a thorough due diligence of the all transaction undertaken under FEMA Act, and you have to know that all transaction have any kind of contravention. You have to rectify the said transaction, you have to identify the default, seek the regularization, and accordingly then go for the compounding. So it cannot be done that you have submitted a compounding application, there was in total 15 transaction under FDI regulations, you have corrected only 10 transactions, you submitted the facts of all the 15 transactions. RBI at the time of scrutiny, they analyzed that there are 5 transactions which gives the contravention, details of contravention, and the applicant has not they have not rectified the said transaction. Your whole application comes back to you, or RBI raises the question that why you have not identified or rectified those particular 5 transactions. So it is very important to take a thorough due diligence and accordingly do the rectification and then go for the regularization of same. The last part to keep in mind, that is that you ensure to provide complete and accurate details in the application with respect to anything which you have mentioned. Any incomplete submission again can lead to return of application or further communication or correspondences from RBI asking you to correct your application. So now we have already talked about the contraventions which can be compounded, but what about the contraventions which cannot be compounded? So there are certain contraventions which cannot be compounding, and there are certain cases in which compounding cannot be done. So first we are talking about the cases in which compounding cannot be done. Here it goes for offenses committed within 3 years of previously compounding offense will not be entertained by the compounding authority. So let's take an example to understand this particular point, that in 2024 April, company ABC Limited submitted an application to RBI to get their contraventions regularized with respect to FDI regulation. And in that, the contraventions was with respect to delay in submission of form FCGPR or delay in submission of form FLA or FCTRS. So whatever the case may be. So you have submitted, you have delayed into the submission of FCGPR, you submit a regularization compounding application to the RBI in April 2024. You got your compounding order accordingly in this particular year. Now, if the same contravention is committed by ABC Limited in 2025, then that particular contravention is non-compoundable because you have committed the same contravention which you just got compounded through RBI. So you are not learning from your mistake. So here RBI says that if you commit any contravention within 3 years from the date of compounding order for which you have like compounding order with respect to a particular non-compliance which you have received, you are committing the same contravention. Now that cannot be compounded. And in those cases, section 13 of the act, where penalty is levied based upon the amount of contravention, and it can go up to 3 times of the amount of contravention, that would be applicable. So no compounding can be done. After 3 years, any subsequent contravention will be treated as first contravention. So you received the compounding order in 2024 with respect to delay in FCGPR, and in 2028 the company again commit the same contravention, and during the whole time they didn't repeated that contravention. So after 3 years from 2024, that particular contravention will be treated as the first contravention, and then you can go ahead with the submission of compounding application to get the same regularized. So non-completion of administrative action can also lead to no compounding. So if an applicant has not completed the administrative action, then their contravention will be treated as non-compoundable. And an indicative list of administrative action, that what does administrative action means? That your transaction was required to be executed post receipt of any approval from RBI or GOI. You have not taken that approval. Now, before going for the compounding, you have to first go to RBI or the GOI, the respective approval authority, to give an application, post facto approval application to the authority, submitting the facts of the transaction which has been undertaken by you, seeking a post facto approval or approval letter from the said authority. Once you get that approval letter, then only your contravention becomes eligible to be compounded. So it is very important to undertake or rectify the contravention or the default undertaken by you in consonance with the provisions provided under the FEMA Act, the rules and the regulation. Okay. Now the other part can be unwinding or reversing the transaction. So if the transaction was prohibited to be undertaken by under FEMA Act, then it is very important for you to first unwind, reverse the transaction, and then go for the compounding. And even in certain cases, we have seen that whenever such kind of a transaction, prohibited transaction gets undertaken by the person, they go for the approval from RBI, they do not receive the approval. That transaction is a restricted transaction. So most of the time RBI does not give you the approval. They ask you to unwind or reverse the transaction, and post doing the same, then you becomes eligible to compound your contravention. The next part is repatriate the receivables or the dues from the foreign party. So if there was any amount which was required to be repatriated to India within a particular specified time frame given under the Act or the respective rules and regulation. So first you have to repatriate that amount, and as you have not repatriated within the prescribed time frame, then you have to go for compounding with the respective RBI office. In case you have not complied with the pricing guidelines, you have not obtained the valuation report, or any other non-compliance with respect to the pricing guideline provisions takes place, then you first have to correct the same and go ahead with the compounding. Compliance with the reporting requirements. So if you have not submitted Form FCGPR in order to report receipt of FDI and allotment of equity instrument to any person resident outside India, so you cannot just directly go to RBI giving them the facts of the case, the statements, and asking them to compound the delay, compound the non-reporting, and they'll just compound it. So this is not going to happen. So first you have to report the transaction under Form FCGPR, then you go ahead with the compounding authority, submitting an application and asking them or requesting them to compound the same, or any other such corrective action as may be required. So we have seen that rectification of the non-contravention is a very important. It is the key to go ahead with the compounding. If you have not rectified the contravention, then you are not eligible to go for the compounding also. So there are certain non-compoundable contraventions. So compounding rules read with compounding master directions gives certain contraventions which are non-compoundable, so that cannot be compounded. So if any contravention is taken place and the amount is not quantifiable, that contravention becomes non-compoundable. With respect to ED, any contravention which are specifically compounded by ED, that becomes non-compoundable contraventions for RBI. That is non-compliance with the provision of section 37A, non-compliance with the provision of section 3A, or the contravention with which involves serious offenses such as money laundering, terrorism, financing, or the contravention resulted to a threat to a national sovereignty or India's integrity. Then these kind of contraventions becomes non-compoundable and the penalty is levied to that. The cases where the adjudicating authority has already analyzed or scrutinized the matter, they have passed an order, they have imposed a penalty. Suppose getting a penalty order, you cannot go to the compounding authority and ask them to compound. Your matter is already adjudicated by the adjudicating authority. They have passed an order, they have imposed a penalty. Then you have to follow that particular order accordingly. You cannot go for the compounding in those cases. And the last, when the compounding authority believes that the contravention undertaken by you requires intervention of ED in order to determine the contravention amount or in order to determine the steps to be taken forward, then those kind of contraventions becomes non-compoundable, and accordingly you have to those contraventions becomes non-compoundable by the RBI. The next concept is discontinuation of adjudication. So once the contravention is compounded before the adjudication starts, so your compounding order is there with you in hand and your adjudication has not been started. So no further inquiry shall be initiated or continued for that contravention against the person involved. So if your contravention has been compounded by the compounding authority, then there will be no adjudication. So any adjudication will discontinue. Discharge on compounding of contravention. So if the contravention is compounded after the complaint under section 16 subsection 3 of FEMA Act takes place, such compounding shall be brought to the notice of relevant adjudicating authority, and on such notice the person against whom the contravention is so compounded shall be discharged. And what does section 16 subsection 3 talks about? It states that no adjudication authority shall conduct an inquiry unless a written complaint is filed by an officer authorized by a central government. So if they gets an application or they gets a written complaint from the authorized officer authorized by the central government, then only the adjudicating authority can start with the adjudication even when the compounding is going on. So at that moment, the ongoing compounding will get discharged. Now coming to personal hearing. So it is very important to understand that RBI gives an option of personal hearing to the contravenor or to the applicant. So opting for personal hearing is not mandatory. It's an opportunity of being heard. So at the time of submission of application, you shall understand that you have to submit all the facts, all the prayers, the reason of the contravention. So it cannot be done, or it shall not be done that you have not stated certain facts into the application and you think that you will submit the same into the personal hearing as you get the opportunity of personal hearing. So this is not the basis of giving an opportunity of personal hearing. So submission of a complete facts and the reasons of delay or reason of contravention, all these things shall be there into the application. Then upon scrutiny of the complete application, you get an opportunity of personal hearing, which is an opportunity of being heard. So this is a voluntary process. It is not mandatory for the applicant to opt it. They can go ahead with not opting the same and receiving the direct compounding order. So if the applicant opts for it, the applicant can accompany with the legal expert or their consultant, as they know the complete case, they understand the FEMA Act. So RBI gives the permission to the applicant to come along with their legal expert or to consultant so that they can lay down the facts which they want to lay down in addition to the application submitted. So personal hearing is basically to know more about the facts which you have not submitted in application, and there shall be reason for the same. Further, appearing for personal hearing does not have any bearing of the compounding amount. So certain applicants and certain clients are things that, okay, if they go ahead with the personal hearing, they will be able to request to the compounding officer to reduce the amount of compounding penalties. This is not the purpose. So the purpose of personal hearing is not to reduce the amount of compounding penalty given into the order or proposed to be given into the order. The purpose of personal hearing that you have not submitted a very genuine point in the application, as you was not aware about that particular fact at that time. So you can opt it or you can opt out for it, but you need to understand that why the personal hearing opportunity is given. And if a person opts for the personal hearing and he or she remains absent due to any reason, then the compounding order authority will pass an order on the basis of available documents. So it's not that you will get an opportunity or you'll get the other date to go ahead with the personal hearing. So if you are unavailable on that particular date, then you have to you will receive a compounding order directly. Now, how the compounding penalty is determined. So compounding master direction provides the penalty metrics, enabling the contravenor itself to calculate the approximate amount of penalty which can be imposed by the compounding authority. So they have given you the complete formula, the list of contravention which are applicable for that particular formula, and you can calculate the same accordingly. So for reporting or any contravention with respect to non-submission of any form under FDI regulation or borrowing or lending on foreign exchange regulation or ODI regulation or any other reporting contravention, which we'll talk about except from LOB or PO. LOB or PO means license office, branch office, or project office. So if there is any contravention with respect to the reporting requirement, then the fixed amount per regulation per rule contravened into the compounding application is INR 10,000. Okay, so here per regulation per rule means that in a particular application with respect to FDI, you have contravened the provisions with respect to submission of FCGPR and FCTRS also. So this for FCGPR, there would be a fixed amount of 10,000. For FCTRS, there would be a fixed amount of 10,000. So for each type of regulation or per rule, you have to pay that fixed amount. Then there is a composition of variable amount as well. So if the amount of contravention is less than 10 lakh rupees, then the amount of penalty will be 1,000 per year. If the contravention continued for 5 years and the amount is less than 10 lakh, so 5 into 1,000 goes to 5,000 rupees. That would be your variable component. And if the amount of contravention lays between 10 lakh to 40 lakh, then it would be 2.5K per year. If the amount is more than 40 lakh but below 100 lakhs, then it would be 7,000 per year. 1 CR or more but below 10 CR, then your per year amount of penalty, the variable component would be 50,000. If amount goes beyond 10 crore, however, it is below 100 crore, then you have to pay 1 lakh rupees per year. And if the amount is more than 100 crores, and then the variable component would be 2 lakh per year. So it is very important to take note that the penalty amount has fixed component as well as the variable component. So if there is any reporting contravention with respect to license office, branch office, or project office, the subject ceiling is INR 2 lakh rupees. In case of project office, the amount imposed shall be calculated on the 10% of the project cost. So for the project office, it is 10% of the total project cost. If there is any contravention with respect to submission of form AAC, APR, or FLA return or share certificate, then the amount of penalty would be 10,000 per form, which is delayed. And for the delay or non-receipt of share certificate, the amount of penalty would be 10,000 per year. The total amount subject to the ceiling of 300% of the amount invested. This particular form AAC is annual activity certificate, which is submitted for the project office, branch offices, or the license offices. So the other type of contravention is non-allotment of equity shares to the person resident outside India after the stipulated time period, that is 30 days from the date of receipt of money, or you have received excess amount of application from the non-resident investor, then you have to refund it. And that refund is 75 days from the date of receipt of amount. Okay. So if you have not complied with the provision of allotment or refund of excess share application money, then the fixed amount of contravention is 30,000. And this is applied once for each regulation or rule contravened in the application submitted, and the variable amount would be calculated on the year basis. So if the contravention continues for less than 1 year, the percentage would be 0.30%. If it's for 1 year to 2 years, then the percentage is 0.35, and it goes on. And in case it is for 5 years or more, then the amount of percentage would be 0.75 into the amount of contravention. And the same calculation goes ahead with any kind of reporting contravention, which we have not talked about in the previous slides. For project offices, the amount of contravention again herein goes maximum with a limit of 10% of the cost of project. Now talking about any contravention pertaining to issuance of guarantee other than the reporting requirements. So if you have not complied with the guarantee provision, then the fixed amount would be 5 lakh rupees, and the variable percentage ranges from 0.05% to 0.75%, depending upon the year, for how much long you have continued with the contravention. That is for less than 1 year to more than 5 years. So for less than 1 year, the minimum percentage is 0.05%. And if your contravention continues for 5 years or more, then you have to pay 0.075% of the amount involved. Further, in case the contravention includes issue of guarantee for raising loans which are invested back into India, then the amount imposed may be tripled even. And the last matrix under the compounding penalty guideline matrix is about all other contraventions, all other non-reporting contraventions undertaken. So the fixed amount therein is 50,000 rupees, and for the variable amount is less than 1 year, it is 0.05% of the amount involved, the contravention amount involved, which ranges to 0.75% if the contravention continued for 5 years or more than that. So you have to follow this particular formula in order to calculate the approximate amount of compounding penalty which can be levied on you. So this was the formula given by the RBI for calculation of penalty. And while you are working on this compounding matrix to calculate the penalty, there are certain notable conditions which are required to be taken note of. Some of the important one I'm describing here. However, there are others as well which you are supposed to take note of. While calculating the number of delays, to calculate that for how much long your contravention continued, so you are not supposed to exclude the Saturdays and Sundays, they will be included. The second one is days to be round off to the next higher month. So if your contravention continued for suppose 6 months and 1 day, so you'll not say that your contravention just carried on for 6 months. There is 1 day as well. So that 6 months will get converted into 7 months. And the penalty amount cannot exceed to 300%. So the maximum amount of penalty can be levied under compounding rules is 300% of the sum involved. Further, it shall be noted that the amount of penalty can be raised up to 3 times, which I've just talked about, that if the amount is quantifiable, it can be raised up to 3 times. So factors determining the amount of penalty. So whenever a compounding authority is analyzing or scrutinizing your application, and at the time of scrutiny, they do take note of certain factors in order to determine the amount of penalty. So the very first factor is undue amount of gain, which is made by the applicant. The other factor is amount of loss caused to the authority as a result of contravention. The next one is repetitive nature of contravention, the track record of applicant, the conduct of the contravenor while under the transaction, and disclosure of full facts in the application. So before passing the compounding order, RBI officer take note of all these factors at the time of scrutiny. So if your track record is not good, then your compounding penalty can be increased, and it will not be as approximated as calculated under the compounding under the compounding metrics. And if you have not disclosed the whole facts under the application, you have hidden certain facts, even then your compounding penalty amount can be increased. So these are the factors which are taken by the RBI into note at the time of scrutiny of application. The last thing is the payment of compounding penalty, that you have received the order, now you have to pay the compounding penalty. So RBI has recently introduced the digital payment options as well for the applicants to pay the compounding penalty amount that can be paid through NEFT RTGS. So they gives you certain instruction to be followed therein while making the payment through the digital payments. Along with the digital payment mode, the traditional demand draft payment is also there. So you can even submit the compounding penalty through the submission of DD. Further, the compounding penalty shall be made within 13 days. So payment must be completed within 15 days, sorry. Failure to pay within the specified time period as stated into the compounding order, this will lead to the application as void, and the FEMA provision, that is section 13, will comes into the picture, and your application will be treated as it never came for the compounding. So you shall pay the compounding penalty as imposed by the RBI office. Last, upon receipt of the penalty, RBI issues a certificate in which it confirms that the whole compounding process is completed and they have received the compounding penalty. So you get a certificate through which you get to know that, okay, your compounding process is over, which is the overall process of 180 days under which your application is submitted with RBI. They scrutinize your application. They ask you for additional information or documentation. They comes to you with the opportunity of being heard. They gives you a fact sheet, you confirm to the same, and then the compounding order is issued. So overall process is completed within 180 days. So now there are two more things we shall talk about, that the late submission fees. So apart from compounding, there is an opportunity for regularization by way of LSF also, which has been granted by RBI, particularly for reporting contraventions. And this LSF comes into picture only when the default is committed from the due date to the 3 years. So if your default is within the limit of 3 years, then only you will get a opportunity of LSF, otherwise you will not get the same opportunity, and you have to get your contravention regularized under compounding regulation. The overall LSF process gets concluded within 30 days, and it is very important to know one fact, that ODI regulations, which was issued by RBI in 2022. So that particular regulatory framework permitted the applicant, the Indian entities or the person resident in India who have undertaken any ODI transaction and they have contravened with any reporting requirement, and or they have not reported any particular transaction. So from 2022, they have 3 years to come to go to their AD bank, report their particular transaction and get the same regularized under LSF. So for example, their contravention took place in 2020. Okay, so for 3 years, they were just having 2023 to get the same regularized through LSF. However, through the regulatory framework in 2022, they can get the same regularized till 2025. October 2025. So the ODI regulatory framework gives you an opportunity of an extended time. Now, the very important question is the role of AD bank. That what is the role of AD bank during this whole compounding process? So we all know that our banks in India acts as a representative of RBI, and they manage reporting requirements, their approval cases on behalf of RBI. But in compounding application, there is no role of the AD bank, and the applicant is required to submit the said application directly to the RBI only. So this is all with respect to compounding rules and the master directions. Thank you.
Okay.
Everyone.
Thank you, Shweta. Thank you giving a detailed one. How to do compounding, what are the penalties, how to calculate, who can do, role of AD bank, everything you have covered. And I hope that the entire point which you have covered, nothing is left out. Even then, there are some issues, some questions and I will request all the participants, if you have any queries, you can give. Now I am starting the question answer session. Okay. So Ankit, my first question is, during internal due diligence, ABC Limited is identify contravention of the provision of FDA regulatory framework, because you have been into. Upon review, it was determined that the company must take corrective action and regularize the non-compliance with the relevant authority. Can I go sumoto application for compounding?
Yes, Shweta also covered that in the presentation, that one can file in sumo motu application, and that's the biggest advantage of going for a compounding.
Okay, so you can go sumoto. So as soon as you are, now question is, you think this is a violation, and when you are filing an application, it is not violation. What will happen?
No, but it's a violation. That is why I'm going. If, for example, in certain cases, we have found that when we have filed the application and it was not an offense, and some regulation change or other thing, RBI has returned the application saying that the offense is no more an offense which needs to be compounded. So nothing to be worrying. So that is also the case.
Okay, okay. Now, next is Mr. A, resident of India, acquired shares of ABC Limited, Indian entity, from PQR Limited. The share transfer document indicate the date of transfer is 1st August 24. Post reviewing the document received, the company recorded the transaction in the books of on 15th August 2024. In compliance with the reporting requirement, A submitted form FCTRS on 30th August, which was subsequently approved by AD Bank with conditional remark instructing ABC Limited to undertake compounding procedure. Okay. Can you just check sound? There is some
Shweta, you can
disturbance.
mute, yes, for the timing. Okay, thank you.
So queries is, what is the contravention committed by ABC Limited? Is it mandatory for ABC Limited to apply for compounding upon receipt of compounding instruction? What are the consequences of not complying with the compounding? So these are three questions, one by one. Ankit, then you and Sweta can add.
I think, sir, the contravention is, I think, as per the requirement of master directions, there is a need to take note of the FCTRS filing before you take note of the approval of transfer. So that's the violation here. The approval was recorded prior to filing of the FCTRS. And once you receive the compounding instructions, it is mandatory. If you don't file the compounding, then at times even if, because in this case the FCTRS would have been filed and then you must have received the compounding instructions. Generally, as part of the mail, it is mentioned that if you are not undertaking the compounding, then the compliance will not be deemed to be fully complete. And then it also gives RBI power, because RBI is aware of the fact that there is a non-compliance, to initiate penal action under section 13, where up to 3 times you can be required to pay the fine. So that's the only drawback of not complying with the compounding instructions.
Okay. Sweta, you want to add anything in this? Some experience which you have?
So, sir, Ankit sir have already covered this point, and even in during my presentation, I have particularly talked about this non-compliance, that whenever a transfer takes place and the Indian entity gets the information of the same, they are supposed to ensure that the resident transferor or resident transferee, whosoever is liable to make the reporting, that reporting is done. So we have already covered this particular point alone.
Okay. Okay. Next. Ankit, in 220, ABC Limited, an Indian entity, granted ESOP to its employee and employees of its Indian origin and foreign, both foreign subsidiary. As per the provision of Rule 8 of NDI rules, Indian companies need to report the grant of ESOP in form ESOP within 30 days from the date of grant. However, the said compliance when uncomplied due to inadvertent omission. In 2024, the company allotted the equity share to the employee post compliance with the exercise provision and proceed to comply with the reporting provision of Form FCGRPR. However, the same was rejected due to non-submission of Form ESOP. What is the action required to be undertaken? Because first you have done some violation, now it has You are issuing and going for this. So earlier thing is not complied. So what to do?
Sir, generally in case of both the filings, whether it's an FDI filing for FCGPR or for an FCTRS, the ED bank always tend to look into that whether they are the connected compliances are being undertaken or not. For example, if you have filed an FCTRS for transfer of shares for which an FCGPR is not filed,
Okay.
then the RBI, the AD bank will point this for a fact and it will not allow the filing approval of FCTRS unless and until FCGPR is filed. Similarly, in case of allotment of ESOPs shares to employees, the requirement of ESOP filing of form ESOP was also there since it was a non-resident. So if you're giving non-resident ESOPs to non-resident, then you have to file the form ESOP before at the time of giving the allotment, allotting the options. And then subsequently, when you allot them shares, you have to file this form FCGPR. So in this case, they have to go for a filing of the form ESOP first. Only post then the form FCGPR will be taken on record. And in most of the cases, this also is subject to compounding, what we have seen.
Okay. Okay. Shweta, you have any point in this ESOP?
No, sir. All points has been covered by sir.
Okay. In the ESOP, any other situation is visualized?
Sir, in ESOPs, actually, there are many situations because considering the time when the grant was made, whether at that point of time you were a non-resident, when you exercised, you were a resident in terms of the payment. So there are a lot of issues connected with ESOPs and the compliances arising out of it. So one need to be very careful to see the requirement of compliance both at the time of grant of options and also at the time of exercise of options when you allot them shares.
Okay. Okay. So what you think that you advise to the corporate that when they do this, they should take care?
So as I mentioned, you need to check the status. If at the time of allotting of ESOPs, it's a non-resident, so you have to file the form ESOPs. And then since it was a non-ESOP, it was a form ESOP been filed, you need to file the form FCGPR in case of allotment of shares. Shweta, even if the status changes from non-resident to resident, even then we have to file?
So if at the time of grant, the person was a non-resident, so that grant of ESOP is equal to a foreign investment. And at the time of allotment, the person becomes resident. So at that time, the nature of the ESOP does not change. So once the FDI, it's always an FDI.
So you need to file the FCGPR. So
You need to file the FCGPR.
both the status needs to be checked at both the point of time and consequent compliances.
Yes, and one more thing, sir, I
Yeah.
think we shall add here that certain companies think that at the time of grant of ESOP, PN3 does not apply. So if you are granting ESOP to a citizen of China or Pakistan, you think that at the time of grant it does not apply. At the time of allotment, if they'll exercise it, the ESOP will get wet. Then the allotment comes into the picture. At that point of time, you have to check it. It's not the case. Even at the time of ESOP, when you have to report from ESOP, the number of equity shares are reported on diluted basis. So it's very important for everyone to understand that at the time of grant also PN3 comes into picture, and you cannot grant ESOP to any employee who is residing into a country sharing the land borders with India without RBI approval. So RBI approval comes before grant of ESOP in these cases.
Okay.
It would be FIPB, I believe. Huh?
Yeah, so FIPB, so
yeah.
the designated.
Next question. The PQR Limited, an Indian entity, complied with an all provision and reporting requirement related to the allotment of equity instrument to a foreign investor. However, the company failed to refund the excess share application money received from the foreign investor within the stipulated time of 75 days from the date of receipt of funds. Subsequently, the company obtained approval from the RBI to refund the excess amount. If the company required to apply to RBI to regularize the delay in refunding the excess amount, even after obtaining approval from the authority.
So in most of the cases, I think the approval is subject to compounding also. So the instructions are given for compounding, and because it was a non-compliance and you've taken a post facto approval. So in the non-compliance still says, and you have to go for compounding even then.
Okay. Okay. Shweta, your point?
So approvals are conditional approvals, and you have to comply with the conditions stated in the approval letter, and you have to go ahead with the compounding. So approval is not the regularization of contravention. Taking approval is the rectification of contravention, and then you have to get the same regularized through following the compounding instructions.
Okay. Next is ABC Limited is a listed company, and the current foreign holding in the company is 5%. Listen carefully. The company is allotting equity share on the preferential basis to foreign investor, resulting to total foreign investment to 8% or 15%. Both the scenario. Okay. Whether the company is required to report the said allotment to inform FCGPR.
So here I think the definition is little confusing. While in case of a listed entity, only 10% and above FCGPR is required. So in case of 15%, it is sure you will need to file an FCGPR unless and until you are an FPI and applying under the FPI quota. But in 8%, as per law, below 8%, 10% is not required, I believe. But AD Bank are suggesting the listed entities to even file even whatever percentage you allot to foreign investors.
Okay. Shweta?
So these are the facts.
Okay, next. Next question is, in April 2019, ABC Limited raised ECB from the foreign investors and complied with the provisional and reporting requirement with maturity period of 5 years. The schedule for prepayment of ECB initiated before completion of minimum average maturity period, that is 5 years. However, the last installment was paid by the company in February 2024, resulting to non-compliance with MAMP with few days. Whether the company is required to get the same regularized and compounded, and how much serious this offense. Shweta.
Minimum average maturity period is a provision which is required to be complied under ECB regulation. So this minimum average maturity period implies to the minimum tenure of the ECB of the borrowing, after which the complete loan can be repaid off. If in your particular case, the MAMP is minimum 5 years, you are eligible to start the repayment on installment basis in such a way that your last installment goes after the minimum average maturity period. However, you scheduled in such a way in compliance with the provision, but during the repayment, your last installment was paid before the MAMP completion, then you have committed a non-compliance. There is a contravention taken place. Now you have to go to the RBI to get the same approved, and accordingly you have to follow the instruction from the RBI and get the same compounding. So it is an offense, or it is a non-compliance undertaken by you advertently or inadvertently, and you have to follow the regularization process, and you have to get the rectification as well. Sir, you are on mute.
PQR, next question. PQR Limited is an Indian company engaged in manufacturing of textile and export the same in certain countries. So this is a manufacturing company and doing export. The company recorded that certain debtors are turned into bad debts and write off the same from the books. During the statutory audit, it was observed that write-off done by the company breached the provision of write-off under automatic route. So, Ankit, first of all, what is the write-off provision and what is the action required to undertake?
Sir, in case of these receivables, there are certain conditions under the export regulations where you can write off certain portion in certain conditions automatically, and in certain conditions subject to approval of RBI or the AD Bank. In case you have breached the provisions of write-off, like for example, there is a condition that you are not subject to any investigation by ED, or the amount should not be more than this amount, total amount of the receivables outstanding. So if you, for example, breached any of these conditions and you have written off voluntarily without complying the conditions in whole, then you have to first go and seek the approval of the AD Bank or the RBI concerned. And then, as we discussed earlier, in many cases, these approvals are subject to conditions of compounding.
Okay. Okay, next question. Mr. A, an Indian resident, invested USD 1000 in USA based company and paid the considerable amount in cash during his business tour to USA. No submission to report the investment is made by A to the RBI. Is this contravention and what action is required to undertake?
Sir, this is a very common mistake that we are finding these days. Because in not in USA, not only in USA, in many European countries, you can just go and set up a company by even $1 or $5. It's as easy as this. So where we have found that many residents, or when they go abroad, meet their friends, or just go and set up a company and give hard cash, they are even due for some reasons. Then, as per the ODI regulations, any investment you made outside India, first the fund has to move through the normal banking channel. So it cannot be a cash transaction. And then once you do that, before initiating the transfer towards that investment, you need to undertake the compliances under the ODI.
Okay.
In many cases, we are seeking that these persons, when, as I mentioned earlier also in my starting introductory comments, that many persons, first what they do, they go ahead and abroad and set up this company, make cash payments. And when they have to really send additional money through the banking channels, at that point of time, generally they go back to AD, because if you are not supposed to send anything additional, you don't go back to AD, you don't do anything, you keep this as status quo. But then when you have to send additional money from your account and you reach out to the AD and ask, who is this company? Then you tell them, this is my company. I have set up. Then they ask you why you have not informed this earlier. The cash investment was not allowed. Then it creates a lot of issues for the person who is setting up the company. So in case of ODI, particularly it is very important that in case you want to go, you can set up a company. Don't make any payments out of there. Payments can only be made through Indian banking channel, and as and when you make the payment, you will be the AD bank will ask you to do the intimation. And the ODI regulations have also been now regularized, which provides that before making the intimation, you have to undertake this reporting with the AD bank. You are on mute.
Ankit, there are so many people are going abroad and they are buying property, they are doing investment, they are forming a company, they are forming company from India. So what message you want to give to them that what they should do?
I think, sir, any foreign transaction, except that these, except for what you do on your travel or vacations, shopping, and those things, any substantial foreign expenditure should always be taken under the consultation of some professional. Because considering these days ED have been acting very swiftly on many of these transactions and sending show cause notices. And it is also important, sir, these days that even outside authorities, there is a lot of coordination between Indian authorities and foreign authorities. And there is a lot of change of information from one authority to another. Indian authorities get a lot of information from their foreign counterpart in terms of the expenditure that Indian residents going there are undertaking. In one of the case we handled where there is an Indian individual who took some cash from some European country to other European countries, and he made a submission to the local authorities there at the airport. The local authorities reported back to after some time to the Indian authorities, and then Indian authorities initiated proceedings against that person. And on what reasons you were carrying cash, you were deposited cash in that bank account. So we have to be very mindful, except the shopping and other things that we do in any investment that we are doing abroad, or any bank account that we are opening to keep any money therein. We should be working or taking those decisions under professional guidance. Otherwise, there will be very grave consequences going through. You are in mute.
Sir, you have any experience of this type of cases? Shweta?
Yes,
You-
sir. As sir has stated the facts, all the facts has been undertaken, and we have seen that these kind of non-compliances takes place.
Okay. In case of reporting non-compliance, if LSF is not imposed, then whether the contravention shall apply for compounding, and if so, with whom, regional office or central office to RBI?
Shweta, you can take this.
Yes, sir. So, if the LSF is not imposed and your non-compliance was firstly eligible to get the LSF, then you can speak to the respective AD bank, as they are the representative of RBI. They can give you some specific reason that why LSF has not been imposed. And if you don't come up with any resolution, then in order to get the same regularized, you can approach RBI while submitting an application stating all the relevant facts. However,
Okay.
first you shall surely go to your AD bank and get the same regularized through the LSF.
Okay. Ankit, there are some question 9(1).
I have
A.
taken note. These are so it is just measuring the.
No, but that is no doubt you have given, but it is better we should tell the for other people.
That's just for noting. I think compounding application can be made through Prabha portal. This is
Yes, sir. So Prabha
yes.
portal, Prabha portal have one of the tab for the compounding application, so you can submit.
But do submit the physical copy.
The physical copy is very important.
Yes.
So Prabha portal does not give you an opportunity to go away from the physical submission. You have to submit the physical set as well.
Okay. This 9(1)(a) not related to allotment of shares, but intimation regarding intimation of inward. I think this is not
because now there's intimation of inward remittance is not required. It used to be the case earlier. Better you can mute.
Just mute. Two companies brought machines from foreign companies, wherein one company ABC and another company RST paid for two and one number machine respectively. But during the billing, all the three machines were billed to ABC and bill of entry of three machine in the name of Mr. ABC. Now, as per the FEMA rules, the payment done by RST has to be refunded back by foreign company. Foreign company is saying that they can only refund the payment once the company ABC transfer them the payment. ABC is not reacting to on this matter after the complaint has been registered against them by RST to their bank. Where should RST log the complaint for fast action?
Sir, I don't think RBI has any role or AD Bank has a locus 24 fast action. They have to reach out to the concerned importer from where the machines have been bought. RBI has no role to play in commercial disputes. They can definitely reach out to AD Bank for a faster resolution of the payment related issues. And generally, in these cases, at times, AD Bank also advises for a tripartite agreement where all three parties are together agreeing to terms and conditions. But there is no other way other than to reach out to the parties engaged. RD Bank and AD Bank will not have much of say in this.
Okay. Our company has 6 NRI investors. The company is listed with the Calcutta Stock Exchange of India. Do we have to make compliance in FEMA for their holding as less than 1% shareholding?
Oh, no compliance is such. If their shares are being held in an FDI, Shweta, they need to file the FLA every year.
If there is any foreign portfolio investment, then
no, not FDI.
We in general,
NRI
there is no FDI, there is only FPI. So
there are 7 NRIs.
It is not required.
Shweta, there are 6 NRIs.
There are 6 NRIs. Then yes, they have to file it. If there is any FDI, you have to.
But Ankit, tell me, what is the difference if this Calcutta, in place of Calcutta Stock Exchange, it is a BSE, NSE, same answer?
That would make a fortune.
Okay. Can the tenure of 180 days be reduced to 90 days?
Really, RBI takes such amount of time. It's not necessarily 6 months. It can be 4 months, 5 months. But 90 days is I have not seen any such case.
Okay. An Indian company has incurred some expenditure in India on behalf of its wholly owned subsidiary situated in Dubai. The Indian company is now planning to regularize these payments made on behalf of its wholly owned subsidiary as financial commitment. Is it possible to regularize these payments by filing the Form FC?
Form FC, I don't think is there anymore. These are ODI forms that needs to be filed, and now planning to regularize these payments on May be heard about. Yes, but then it will be deemed to be delayed filing.
Okay. Shweta, you have any view on this?
So same views.
Okay. Now, the last question: the company has issued CCD in 2000.
Shweta, but the only thing is, sir, he has incurred the expenditure in India, not outside India. Has incurred some expenditures in India on behalf of its wholly owned subsidiary situated outside Dubai. That cannot be a financial commitment. Financial commitment is towards that company. It should be seen. Okay, we'll review this.
This would be, sir, taking any expenditure on behalf of the foreign entity in India. This would be like a current account transaction, reimbursement of expense. You have to just repatriate
You asked
amount.
Okay.
Mr. Dharam Singh Rathore, you can ask further answer to them and give their
Yes, sir. Yes, sir. But this is the reply that it would be treated as a reimbursement of expenses, and he is supposed to repatriate that particular amount.
You just talk to him. So
Sure. We will.
The company has issued CCD in 2018 with the interest component of 9.5%. The company converted the CCD when they were due for conversion. The company has not paid the interest components so far, and the accumulated amount of interest as on date is around rupees 2 crore. The company proposed to allot shares against the interest component, and the CCD holder has agreed to it. Can the company allot shares against the accumulated interest component?
So, prima facie conversion of any due into equity share is permitted if the payment of receipt of that due is permitted. So if something can be done directly, it can be done indirectly. So prima facie, it seems yes, but we can even check it because it's particularly talks about the interest. So in case, like taking an example of export receivable. So if there is any export receivable pending to be received and the foreign entity is not able to repay that amount, so they can convert that export receivable into equity shares, and they can allot equity shares of their own company to the Indian supplier. So taking the same view, the interest is also supposed to be paid, and then if interest can be paid in cash, then in general RBI allows conversion of equity, but still this particular matter is subject to certain research.
It seems doable.
Yes.
Okay. So, Shweta, both the Pradyumna and Dharam Singh Rathore, just talk to them whether their queries settled, or in case there is any other additional facts, just get it and do it. So, friends.
Yeah, sure, sir.
Yeah. So now it's a time to close this session. It's a 4 minutes to go to 6 o'clock. We try to finish our program in 4 to 6. As you are aware that we try to give all answers of your queries. We try to give all points, all the presentation. The presentation I have told you, it will be given to all of you. Shivam will send the presentation, and in case your query is not clearly answered or some issues are there, you can directly talk to us. Our team will talk to you. Or any additional point is also there, you can talk to us. So friends, I have to make two announcements. First, I want to thank Shweta and Ankit for giving a nice presentation and detailed one, and giving the answer of all queries which you have, which was asked. Okay. One more question has come. Ankit, I think you should answer. We have 2 minutes. Letter of taken on record in year 2022 against share transfer with condition directing compounding application. Can I file now for compounding? How much compounding?
You can file for compounding, but generally you have to check with the bank. You can file. How much compounding will depend upon the quantum of the involved and the contravention.
Okay. Okay. So thank you very much. Thank you, Shweta. Thank you, Ankit, and thank you all participants. Friends, time to close. As you are aware that I have informed you that our 200th webinar is on 20th December. I will request all of you to register for them. We are inviting the prominent speaker of India on all walk of life relating to this, and topic is also very interesting and futuristic topic. The catalyst for corporate growth, unveiling the next wave of regulatory reforms. What are the reforms required that we want to discuss, and you can register yourself. Next is this journey of knowledge sharing will continue. So our next webinar is 199, that is on 13 December, Materiality Code for ESG Analysis. So I request all of you to register for this webinar, which is there, and we'll talk about the ESG analysis for Materiality Code, which is now a very important aspect which we want to discuss. Till then, thank you very much. See you.
Thank you.